Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. Got a message from a fellow business owner the other day. Thought I'd make a great video. And he asked me, he goes, Joe, if we could put in a limitation of liability clause in our contract, what's the point of even having E&O insurance? And today I'm going to be talking about that topic. We're going to be seeing if it is going to be the saving grace of your business, a fool's errand, or most likely kind of something in between. Before we jump into that, that's my latest book, Damage Control, Cyber Insurance, and Compliance. If you want to learn about that topic, that's the link where you can download it for free. Now, before we jump into this, I am not your attorney. I'm not providing any sort of legal advice in any fashion whatsoever. I'm not giving you any sort of official insurance advice. Please speak with a competent attorney who is familiar with your own particular circumstances. And of course, at the end of the day, I am but a head inside of a little bubble here talking on the internet, so there's no reason to trust me about this particular topic. Now, if you're not aware, let's just do a little background here on what a limitation of liability clause actually is. So they can be found in contracts, and generally what they're doing is they're trying to limit the amount of damages. Generally, that's going to be money that can be recovered from a negligent party. So you as a business owner, you would be concerned about, hey, if some other business damages me, how much can I get out of them? And if somebody says that I damaged them, how much can they get out of me? That's what we're talking about here. An example of a limitation of liability clause would be some clause that essentially states, hey, the most that you can recover given some type of lawsuit would be, let's say, the amount of fees that you have already paid me under this particular engagement or in this particular contract. Now, please do not confuse these with something called an exculpatory clause. So a limitation of liability is just that. It's limiting liability. An exculpatory clause is trying to, we could just say generally, avoid liability. So an easy way to think about that is like the get out of jail free card in Monopoly. So as I've said, it generally tries to exonerate a party from any of its future conduct. This can actually be disfavored under many state laws. It could also be strictly construed against the party trying to claim this benefit. And so obviously courts just may not look favorably upon some type of exculpatory clause. Now, how enforceable are these limitation of liability clauses, right? We're jumping back to those. How enforceable are those? Well, like all things, it just kind of depends, frankly. Some states allow this. Some states have varying degrees of unenforceability. Some states give them very careful scrutiny on the exact wording within that particular clause in the contract. And then some states have something called an anti-indemnity statute, making them generally unenforceable. But as I've said in bullet point number 1 there, it just depends. So very generally speaking, what are courts looking for? Let's say you want to contractually limit damages that could be awarded. This can actually be useful. Obviously, speak to your attorney. But here's what they're looking for. These 4 things. Now, this can vary by jurisdiction and the case and just the fact pattern of the case. And we're going to look at that here in a second. So please talk to your attorney. Those words in the bullet points there, that's not what we just assume that they would mean. They could have very well-defined legal definitions. So make sure you're keeping that into account. Now let's look at the case of Blaylock Grading Company versus Smith. Now, Blaylock and Neil Smith Engineering. Smith was a professional land surveying company sued over alleged professional negligence. The contract had roughly stated the following. Smith's potential liability was the greater of either $50,000 or the total amount of fees paid to Smith, right? So that right there looks like the limitation of liability clause being brought to the forefront in this case. Now, Blaylock had argued that that limitation of liability clause actually violated North Carolina's anti-indemnity statute, which you can look up there if you feel so inclined, and thus was unenforceable. So Blaylock was trying to say, hey, this violates the law here in North Carolina. That should be stripped, and therefore we, Blaylock, should likely be able to get more money out of Smith Engineering. So what do you think the courts actually said here, given the knowledge that you have so far on this particular topic? Well, the court held that the contract actually did not violate North Carolina law. There were no irregularities in contract formation. The contract was not unconscionable. There was no inequality in the sort of bargaining power. Ergo, both parties were sophisticated professionals. And the limitation of liability clause, that was not the same as an indemnity clause. So now you're probably sitting here going, wait. How does that make any sense? Well, that's kind of the point of all of this. That's why I picked this particular case. So don't ask for or receive legal advice over the internet. That means just because somebody else, like your buddy is a fellow business owner in your particular industry, that doesn't mean that you can just take his contract whole cloth, change the names on it, and use it for your own. It also means that the law it's very complicated and it's very nuanced. Choice of venue is also a complicated legal matter. So you probably want to talk to your attorney about that as well, because the venue where the case is actually held, that could have an impact on the enforceability or potential complete unenforceability of a limitation of liability clause. Speak with a competent legal professional familiar with your circumstances. This is a place where when you're looking at contracts, you really need to think, okay, this could be money very well spent. This could be the difference between you actually staying in business and you going out of business. So make sure you're talking to those competent legal professionals to assist you there. And then, of course, kind of long story short, hey, you still need to have appropriate insurance, right? Because maybe it turns out that just by the fact pattern of that case, the one that you're working on, when the totality of circumstances is brought together, that limitation of liability clause may not be enforceable. But hey, if you have it in there, at least it's something, right? Talk to your attorney, see if that is a useful strategy for your particular business. All right, with that, once again, that's where you can download my book. Right above my beautiful head here, you will see another video about why having a cyber attorney is probably a very good idea for you and all the wonderful things they can do. And over there, you'll see another picture of my beautiful face. Click on that. You can subscribe to the channel. With that, stay safe.